This is Speak Up. I am Sandra Schulte. Welcome back to our show. Today, I'm very thrilled to have Professor Thomas Rosinski with us. Professor Thomas Rosinski is a principal pre-law advisor for all of the Touro University students. He is the current president of the New York Association of Pre-Law Advising and Pedagogy. He was graduated summa cum laude, can't do better than that, from Yale University. He has an MA from Harvard in government and a JD cum laude from Harvard Law School. Before joining Touro, Professor Rosinski practiced law at two large law firms in Manhattan. He was partner at Anderson Kill and Olick. His then partner, Rudolph Giuliani, was elected mayor, and Tom joined him in the New York City government, serving as general counsel to two city agencies and also as commissioner of homeless services in 2001. After that, he taught at the University of Michigan. Then he came to Touro in 2006. And now here he is. And I'm going to ask Professor Rosinski to please talk about something that I think is going to be a major issue. He's going to talk about how Dobbs is establishing a new constitutional right for women. Please.
Well, thank you very much, Sandra. So recently, the Supreme Court in Dobbs versus Jackson Women's Health Organization struck down what had been a constitutional right for 49 years, and that was the right of a woman to have an abortion. In the opinion by Justice Alito, he said that because there is no right to abortion mentioned in the Constitution, any such right would have to be found in the history and tradition of the United States.
Very important, history and tradition.
And in our history and tradition, there was no real discussion of a right to abortion until the 1960s. And while women did have abortions before, that wasn't a matter of right. It was simply because for a long period of time, women could have early term abortions prior to quickening or the movement of the fetus. And so what he said was, since there's no constitutional right, the law in Mississippi merely had to satisfy what's called the rational relationship test.
So in other words, it had to be in the Constitution. It couldn't be custom or someone's done it before.
Well, if there had been some recognition of a right that wasn't mentioned, such as, for example, the court has said you have a right to get married, even though it's not in the Constitution, right? But in this particular case, there was no history of a right to abortion. And so because of that, they said there's no reason why Mississippi can't restrict abortion after the first 15 weeks or so of pregnancy. And he said that the state's interest in doing so was to protect unborn life. However, in doing so, what he essentially said is that women in Mississippi and in many other states that after Dobbs have adopted or resurrected laws banning abortion, that essentially the government now is allowed to regulate and take over the bodies of women who are pregnant. And that implicates another very important clause in our Constitution, and that's called the Just Compensation Clause. It's the last part of the Fifth Amendment, and it says, nor shall private property be taken for public use without just compensation.
Very interesting. Nor shall private property be taken for public use without just compensation. Very important.
Okay, so let me give you an example of how this works.
Go on.
Let's suppose that the FBI believes that your next door neighbor is engaged in some suspicious activity, and it believes it needs to undertake surveillance in order to get a search warrant. Now, it can get an order from a judge, basically forcing you to allow it to use a room in your house for the purposes of surveillance. But that would be taking over your property, and you'd be entitled to compensation for the use of that room, any additional expenses you had, such as higher utilities, and also any loss of business, such as not being able to have clients come into your home. In this particular case, what Mississippi basically says to women after the 15-week period is, we are going to take over your womb. We're going to tell you how you need to live, what rules you need to follow, such as not drinking, not perhaps engaging in strenuous exercise. We're going to expect you to have regular prenatal care. And we are most importantly going to tell you that you must carry this baby to term. Now, this imposes a lot of costs on women. Right? And it's not just the fact that there might be increased money for food or for doctor's appointments or for maternity clothes. Carrying a fetus to term increases the risk of death by about 14 times. That's what the dissent in the Dobbs case said. It increases the risk that a woman faces. And so what we have here is the government is imposing additional costs on women for a public purpose, which basically is creating new citizens. And the Supreme Court said, that's fine. We get new citizens because of the state's interest in life. So the question is, Sandra, is this a taking? And is the mother entitled to compensation under the Constitution? So let's look at three things. First of all, is it a taking? Very clearly, she's not able to do what she wanted to do. She is required to change her life, often dramatically. So it's certainly taking her body for a particular purpose. Secondly, is it for a public purpose? Well, the court has said yes. This is a public purpose, protecting unborn life and future citizens. And so the question is, what is just compensation?
That's a big question.
It's a big question, but it's one the courts have not had difficulty figuring out, because essentially what they've said is, what are the economic costs that a person has from carrying a fetus to term? And those are the cost of medical care, the cost of additional food, of clothing, of perhaps time taken off from work, and the actual cost of giving birth. And so basically, under well-established Supreme Court jurisprudence that goes back well over 100 years, it would seem that the consequence of allowing states to bar abortion is that it creates a right for all pregnant women to obtain compensation for the costs of pregnancy.
Sounds like rent a room to me.
Well, in a sense, that's what it is, right?
Yes.
And see, my concern is that women's rights advocates will spend a lot of time trying to fight this decision. But politically, we're not going to overturn Dobbs in a short period of time. Right. The Supreme Court's not going to change. There aren't the votes to put new people on the Supreme Court. We're stuck with the Dobbs decision.
So they have to decide what is doable.
So the point is that rather than lament and say, oh, this is a terrible decision, it set back the cause of women, why not look at it and say, well, maybe it actually can be used to advance the cause of women? Because when you think about it, women provide us, through caring for fetuses to the point of birth, a service that men can't provide. And one of the reasons the Supreme Court has recognized as the purpose of the Just Compensation Clause was in a case called United States versus Armstrong, where it said where certain people have to bear more of the cost of something that benefits everyone, they should receive compensation. So why shouldn't all pregnant women receive compensation from the moment at which they can no longer reverse their pregnancy up until the moment that they give birth? Doesn't that make sense?
It makes sense to me. I also feel they should be compensated for the use of their womb.
Exactly. Now, if you think, okay, well, this is going too far, a woman is able to give up a child for adoption once it's born. So at that point, retaining the child becomes a matter for choice. But for the period of time defined as when she can no longer have an abortion until she gives birth, she's required to do what the government tells her. And if the government thinks she's not taking adequate care of that fetus, it can put her in jail. There are instances of women who've been found using drugs or drinking or engaging in what's considered to be dangerous activity, who've been confined against their will until they give birth.
Interesting.
And that's also a risk that she would have to suffer. So it seems to me that this is one of the directions the women's movement should go in. And think about what this would bring to our society. It would mean that whether you're rich or poor, you have all the resources necessary for you to carry your fetus to birth, for you to finish the creation of a human being. And so the government would have to give resources to people who are indigent, who don't have them. Now, some people might be happy with their health insurance. There might not be a lot of additional costs on their part. But for those who need assistance, we should be equalizing this. Because right now, the risk of suffering serious harm or death for a poor woman who's pregnant is much greater than that for a wealthy woman who's pregnant. So shouldn't the government have to assume the difference there? Everyone's contributing to the citizen pool by creating life. So why should we impose additional harms or allow additional harms to be imposed on women who are poor?
And I ask myself, what if a woman dies in pregnancy? This is then becomes a cost to the family and her lack of life.
Well, the risk of death is a big problem under many of these statutes because some of them allow doctors to give abortions for women who face a risk to their life. But the problem is that risk to their life is not very well defined. And so we know that women who are pregnant have a 1 or 2% chance of not making it, perhaps lower than that. Mm-hmm. But let's suppose that the doctors detect something, perhaps because of fetal abnormality or a problem with the woman's womb or something like that, that doubles the risk that she would possibly die by giving birth. Is a 100% increase enough? What about a 50% increase? What if the risk of her dying through a normal pregnancy is just 1%, but it doubles to 2%? Is that enough for a doctor to do it? Or might some states say, well, you've got a 98% chance of survival. No, you can't remove the fetus from the woman's womb.
And that's probably what will happen.
Well, this is a real concern, and this is something that doctors face problems of prosecution for.
Yeah.
Because the way a lot of these statutes are written, it's not the woman that is punished for this. It's the doctor that provides the abortion.
I see.
Doctors have a Hippocratic oath that requires them to preserve the life of their patients. And if they believe that a woman suffers a higher risk from a pregnancy, then it's his duty to the woman to have an abortion. But what if the state says, we don't agree with that? We don't think that this is a high enough risk to have an abortion.
And that's what will happen.
Well, we don't know, but it's certainly a risk because
Yes.
essentially the state has taken control of the woman's body. You think about what this is going to cause here. I mean, think about other controls that states might decide to put on women. Because essentially, reversing Roe versus Wade turns us back 50 years. And 50 years ago, women didn't have anywhere near the equality of rights that they do now. What's
right.
to stop a state from saying, we don't believe that women should drink when they're pregnant? And since we don't know whether someone's pregnant, and a woman doesn't know right away either, why don't we bar drinking by all women at an age at which they're likely to get pregnant? And so the women's drinking age goes up to 45, or maybe even 50 these days.
Or maybe certain forms of work should not be done by women.
Well, that's another big problem, too. I mean, one of the things that has happened with the Supreme Court, largely through the advocacy of Ruth Bader Ginsburg, as well as some of her decision-making, was to equalize rights between men and women. This is something that Congress tried to do in 1972 when it passed the Equal Rights Amendment. And all that had to happen was that 38 states had to ratify it. Well, we got fairly close, but we didn't get 38 within the 7-year period. And so, believe it or not, we do not have an Equal Rights Amendment to our Constitution. Women can justifiably and constitutionally be treated differently than men. And this is something that many people worry about, is that we're going back to a period where women have reduced rights and less rights than men. And that's not something that our Constitution, at least in its Equal Protection Clause, should really be doing.
And is there anything in the Constitution that talks about how amendments are made?
Well, it's Article 5 of the Constitution, and it's very specific. It says that a constitutional amendment can be done if 2/3 of both houses of Congress pass the resolution, and that resolution is approved by 3/4 of the states. That's all that has to happen. There is no time requirement for ratification.
Was the amendment approved by 3/4 of the states?
It has now been approved by 3/4 of the states because we now have 38 states that have ratified it.
Interesting.
And so let's think about the last constitutional amendment. Many people don't know much about the history of the 27th Amendment, the last amendment to be added to the Constitution in 1992.
Please.
It was actually part of the original Bill of Rights, the same Bill of Rights that contains the Just Compensation Clause. And it basically says that congressmen may not receive an increase in their salary until after an election has taken place. It was basically put in there so that Congress couldn't vote itself an immediate pay raise and take all the money and leave town. They have to be revoted back in. And so this is something that passed Congress in 1789. It was sent to the states to be ratified, but it never got ratified until in 1981, a college student at the University of Texas in Austin wrote a term paper about it. And he said to his professor, Sharon Waite, this is still a live amendment. There's no time period for ratification. Well, she thought this was bogus. She gave him a C. And he went on to prove her wrong. Because what he started doing after he graduated was contacting legislatures throughout the country saying, isn't this a good idea? We don't want Congress just passing massive increases in their salary and keeping it. Well, in 1989, Congress passed a 40% pay raise. And people were so upset, they said, yes, we've got to have this amendment. And in 1992, Michigan became the 38th state, ratifying a constitutional amendment that was passed in 1789 and took effect 203 years later.
Repeat the dates.
1789, 1992.
Very interesting.
So Congress, in the Equal Rights Amendment, put in a 7-year ratification limit. But there's no constitutional authority for it doing that. It basically just acted on its own. Many people called it the giddy-up clause. In other words, let's get this ratified within 7 years. Let's not waste our time. But it has no constitutional support. And one of the things that the Supreme Court seems to do is to take the Constitution as it's written. They take it seriously. It doesn't say Congress can do this, so how can Congress put a time limit in?
Very interesting.
What that means is that the Equal Rights Amendment is not subject to a 7-year ratification period. The moment it passed the House and the Senate,
it was active.
It's active, and it is active until 38 states ratify it. Now, the other issue here is that some states have rescinded their ratification.
Oh dear. How?
But the Supreme Court has said, in a case back in the 1930s, that there's no constitutional authority for ratifications to be rescinded. In other words, it's a one-way switch. Once you turn it on, it's on. You can't turn it off again.
Fascinating.
Now, it's up to the president to declare a constitutional amendment ratified. And President Biden has been asked to do this, but he hasn't yet done it.
Does it say in the Constitution that the president has to declare an amendment active?
Well, we have something called the Take Care Clause. The president shall take care that the laws of the United States be faithfully enforced. And so this would seem to be one of the responsibilities of the president. If a constitutional amendment is validly passed and ratified by 38 states, he should say the Equal Rights Amendment is in effect. And this would be another way of trying to help protect women's rights at a time when they are under siege now more than at any time in the last 49 years.
I think this is something that really needs to be, it needs a lot of notice, let's put it that way.
Well, I think it's something that the press really hasn't focused on. You don't really see much of a campaign for this. And yet, it seems to me that the easiest way it could be done is through a statement of ratification by President Biden. And if somebody wants to challenge it in court, let them take it to the Supreme Court. But at least that way, we have a decision as to what Article 5 of the Constitution means. But if the president's unwilling to take this courageous step, then women risk being put in a position where more of their rights can be taken away under the guise of, well, you could become pregnant, so we're going to have to restrict what you can do.
Would you go back to the Due Process Clause?
Well, I think that the Due Process Clause really relates to the right to abortion. And what the Supreme Court said in 1973 in Roe versus Wade, that a woman has the liberty to control her own reproductive organs. That liberty no longer exists. It has been taken away because the court said, well, we didn't think it was a right back in the 18th or 19th century. What's really interesting, though, is the just compensation clause, because it's the one clause in the Bill of Rights that none of the states advocated. In other words, it's just something that James Madison slipped in because he was afraid that government might take advantage of people. And if you read the Federalist Papers, and the Supreme Court's a big supporter of the Federalist Papers, it talks about the need for there to be checks and balances on government. And the just compensation clause essentially says government can't take your property just because it might be helpful to everyone. It's got to compensate you for the market value of that.
Market value. How does one determine market value? That's going to be a big issue.
Except that when you think about it, it's what are the additional costs that a pregnant woman has? You can add these things up. It cost her $500 more for additional food. It costs her $1,000 more for visits to the doctor. It cost her $1,000 more for maternal clothes. And she had to quit work after 8 months. So whatever salary she was making for that 9th month, that should also be reimbursed to her if her employer is not compensating
She better
her
keep
for it.
her books and her receipts.
But that's, that's not that uncommon. I mean, if you want a tax refund, you got to keep receipts too. But this is something that really, it's for all women, right? All women have the right to claim it, rich as well as poor. But it's the poor people that it really helps the most. Because if you already are receiving those benefits from your insurance or from your employer, you don't necessarily need this payment. But if you're not, you do.
And it's also very important because it's important to raise a healthy infant.
If the state's interest is in protecting unborn life, that means that mothers need to give good prenatal care to the fetuses that they're carrying. And so this benefits everyone. It doesn't help society to have children that have poor prenatal care and as a result have to have lots of doctor's care early or later in life. So there's no question that the benefits from this are well worth the costs. And it's just, it seems to me this is where the direction of the women's movement should be going right now. Women's rights movement, pushing for a right to compensation for all mothers. If the state says you must have a child, the state should be willing to pay for the cost of having that child, right?
Makes sense to me.
I think it makes a lot of sense, and I think this is something that we should have more discussion about. And I think it's something that states that are considering adopting legislation like this need to take into account in their planning. They want to have more children. That's the purpose of ending abortion. Well, then they need to pay women for the services they're providing to the community. That's what our Constitution says.
Well, they also the court also said that a child, an infant, is a private individual. But the problem is with being private individual is a private individual can't make decisions for himself. A private individual cannot clothe himself. He can't really act for himself until a certain age. So shouldn't the woman have compensation to do those, to help the child?
Well, that's the point. Essentially, when the state says to a woman, you must bring this child to birth, it's essentially conscripting part of her body to provide a service to the state.
Yes.
And it's also making her, in a sense, a government contractor, isn't it?
It certainly
because
is.
Because it says, you're doing this as a job for us.
To raise a citizen, a good citizen,
and if it's
a competent citizen.
Every woman that wants to have an abortion but can't, or really every woman that has a child is performing a service to the state, because it's not limited by whether you want to have an abortion or not.
Right.
This is a right that should be available to all women, whether or not they're thinking about having an abortion. The moment you can no longer exercise reproductive choice on your body is the moment your right to payment from the government kicks in. And whether that's at conception, as it is in Oklahoma, or at 6 weeks, as it is in some states, or 15 weeks, or 20 weeks, or later than that in a state like New York. It's a right that women in every state should have. Not just limited to states that have restrictive laws, but every state in this country places restrictions on a woman's right to have abortion. Late-term abortions in all states are severely restricted. And so the moment at which a woman no longer has that choice is the moment at which this right should kick in.
To me, it should extend beyond her leaving the hospital, because a woman has to take care of that child. The child, he may be a private individual, but he's not independent.
Well, that's true, okay, but you understand that a woman has a choice.
She can give him up.
She can give him or her up, right?
That's true.
Okay, and that's not a choice she faces during the period of time for which she can have an abortion. And it's the absence of choice that creates the right.
Okay.
If you can walk away, that means that your decision to keep your child, and the vast majority of women keep their children.
Yes.
That's a choice you make. And we have various other aid programs. But as you know, there's no constitutional right to support a child during the period of childhood, even though, of course, you're also producing them and they're providing benefits to the state. But that's a question we can have for another day.
That's true. Professor Rescind, I want to thank you so much for having come on our show. You couldn't have been more informative. I want to thank you for all the women out there who are going to be affected by this abortion issue.
Well, thank you very much for listening to me and having me on today.
This is Speak Up with Sandra Schulte. Thank you so much for coming back to our show. Have a wonderful, wonderful rest of the day. Goodbye.